Welcome to Civil Litigation Week. As far as this week is concerned, Module 3 we shall be doing with interlocutory applications and hearing and of civil suits. So under this module, we are introducing students to intervention as counsel in an existing suit, interlocutory applications, and hearing of civil suits. So basically, when we talk about interlocutory applications, we mean those applications which always arise before the final suit is heard. So this one can include application for temporary injunction, application for security of costs, also application for contempt of court, among others, also attachment before judgment, or some of the interlocutory applications we shall be looking at. So learning outcomes, by the end of this module, you will be able to, one, explain the process of intervention by counsel in an existing suit, interlocutory applications, and during the hearing of civil suits. So basically, when we talk about intervention of counsel, it means that counsel can intervene in two ways. One, when there is withdrawal of instructions from the first advocate, and then have been given instructions, they have to proceed and file what we call notes of change of advocates. But also it could be joint instructions where, for example, the client is being represented by more than two advocates. So you have to as well file or what we call joint instructions. Then present interlocutory applications. Basically, here we shall look at temporary injunctions, ex parte interim orders, as well as interim orders, application for security of costs, application to consolidate suits, as well as test suits. We shall look at present civil suits. Basically, how is the civil suits presented, ESCO issues involved, including not overcharging clients, of course, avoiding conflict of interests, and also making sure you do proper due diligence. So workshop 1, we are saying that this workshop deals with the process of intervention by counsel in an existing suit, contentious and non-contentious applications made to promote interests of justice and for better case management. So basically, when we talk about intervention by counsel, it basically means you have to file what we call a notice of change of advocates if you are changing from one law firm to another. But also we can have a joint instructions whereby two law firms will be working on the same case. Learning outcomes, by the end of the workshop, students should, one, explain the process of intervention by counsel in an existing suit, prosecution of interlocutory applications, and preparation of rulings in respect of the interlocutory applications. So basically, I've told that interlocutory applications include applications for temporary injunction. And one of the grounds for application for temporary injunction is that there must be a prima facie case, irreparable damage, as well as the balance of convenience. And I think those ones were explained in the case of Kayimba Kagwa versus Haji Natha Hassan Katendes. But the locus classics case, as far as temporary injunctions are concerned, we have that Kayimba case. Then we shall also look at a procedure of interlocutory applications and preparation of rulings in respect of the interlocutory applications. So basically, the grounds for temporary injunction, one is existence of prima facie case or suit. That basically means that you must have filed a suit with a high probability of success. Then you look at balance of convenience, that the convenience must be in the favor of the applicant. And then you look at reparable damage, which will mean damage which cannot be compensated by any loss. I illustrate the ability to draft appropriate form of applications, replies thereto, and submissions. Develop ability to demonstrate prosecution and termination of interlocutory applications, and demonstrate case management procedures to save cost time, where we shall look at test suits, where you have many suits against one defendant. You try one suit, and if he's found liable, then the liability cuts across all other cases, what we call test suits. We shall also look at consolidation of suits, basically where you have more than two cases against the same party. You can also consolidate them, and then you try them under the same trial process. Recognize the ESCO issues. So part A, assume you're a legal assistant at MSOLA and company advocates. This morning, Mr. John Magoba is before you and narrates you the following. He purchased the land at Munyagwa and is in occupation, but later Festo Chohirwe came and obtained a certificate of title. A suit was filed by Chohirwe, and he filed his defense and counterclaim, copies of which are attached and marked A and B. This morning, Festo Chohirwe has started powering construction materials on the same. He brought several casual workers on site who have started digging a foundation. He instructed lawyers who filed his defense in court, but he feels they are slow and may not prevent Festo from a completely changing state in which the land appears. He's worried that Festo's actions are going to lead him to completely lose the land. He wants you to join the team and expedite the matter. Advise the client on the most appropriate remedy available to him in the circumstances. So basically here, where we have because he wants you to join that team. So that means you have to file what we call joint instructions, whereby you are also coming on this team. So we have what we call notice of change of advocates that applies when you are changing advocates. But here, where you are supposed to work with another law firm, you file what we call joint of instructions. So basically advise the client on the most appropriate remedy available to him in the circumstances. We shall have to file what we call a joint of instructions. Then from there we shall look at application for temporary injunction. What's the course of action you're going to take in order to effectively protect the client's interests against the current activities in form of the suit land. Basically here you apply for temporary injunction, and it's always by chamber summons supported by an affidavit in support. And remember, according to the case of Chimbakagwa, you must prove one prima facie case, which we have. Secondly, we have also balance of convenience, and third, irreparable damage. Basically those are 3 grounds you have to provide to go under temporary injunction. But also you have to be aware of the fact that you can also apply for what we call ex parte interim application, which is under the amendment of the civil procedure rules, and there you can be given an order for 3 days, as you also apply for interim order. So the interim order is always the interim order is by notice of motion supported by an affidavit, but because the temporary injunction might take long, that's why you have to apply for what we call an interim order. So draft the necessary documents you would file in court in view of the desired remedy in one above. So basically we have applications for temporary injunctions as well as application for interim order, which is by notice of motion supported by an affidavit, whereas for temporary injunction is chamber summons supported by an affidavit. Prepare written submissions you would use in court to support the desired remedy. So basically for the temporary injunction, I would also submit on existence of the prima facie suit, second, irreparable damage, as well as third, you also have to submit on the balance of inconvenience. Whereas for the interim order, you have to submit on one existence of the imminent threat or danger, and also there must be an application for temporary injunction. So you have to basically submit on those 2 grounds: one, existence of an application for temporary injunction, and imminent threat or harm, and also which basically needs to maintain the status quo. So basically the written submission shall be as preparing as far as task A is concerned. So part B, assume your accounts for the defendant after filing written statement of defense, a copy of which is here to attached and marked B. Your client Magoba informs you that apart from the disputed land, the plaintiff has no known property or income in Uganda. In fact, they recently obtained a green card from U.S. Embassy in Uganda and is preparing to report to USA rumors. So basically advise your client on the most appropriate remedy in the circumstances. So basically here you would have to apply for security of costs. You have to apply for security of costs, and then security of costs basically you have to prove that the person has no any known property within Uganda, and he's planning to leave the jurisdiction. So basically there you proceed to apply what we call security for costs, and security for costs are provided for by the civil procedure rules. So I think that the necessary documents will be drawing is the chamber summons supported by an affidavit. But you have to look at the civil procedure rules and then confirm the documents, because when you look at the security for costs, basically on the last rule, it always provides you with the procedure. And if it's not there, that basically means that you proceed by notice of motion. But if they are providing for chamber summons, then you proceed for chamber summons. So please cross-check with the civil procedure rules and the order that establishes security for costs, and then you can be in position to advise on necessary documents. Then Part C, assume that as counsel for the defendant, you secured orders in Part A above, but the plaintiff has continued to bring materials on the land, and the construction of the foundation is now complete. So assume that as counsel for the defendant, you secured orders in Part A above. Advise the client on the most appropriate remedy available to him in the circumstances. So basically, you have to apply for contempt of court, and contempt of court have to prove one, there is a lawful order, the order was served to the defendant, and the defendant failed to comply. So basically, when you have those contempt of court, you can proceed, and then the documents in the notice of motion supported by an affidavit, then prepare written submissions. Basically, we shall argue that there was a lawful order, the order was served to the defendant, and the defendant failed to comply. Those are the ingredients for you to prove in contempt of court. Part D, following the eviction excuse that happened in Rusaja in Waxhaw District, several victims, including Kemisto Kamakech, Master and Gloria Kamakech, each filed a suit against Brado Ruzio in Pidge High School seeking for following orders: a declaration that the eviction was illegal, special and general damages, costs of the suit. The High Court set different dates for the said duties. Advise your client on the course of action you would have to take to expedite the hearing and write the necessary documents. So basically, here we have two options. One is test suits. I talked about test suits as a situation where you have more than one cases against the plaintiff, the defendant, and basically what you have to do is that you have to the defendant, they can bring what we call test suits, and the test suits, one suit is tried to basically prove the liability of the defendant. Then also talked about what we call test suit. Then talked about what we call consolidation of suits, which is the most appropriate. In consolidation of suits, all suits are consolidated, and then we have one trial. So basically, that's what we should be looking at here. Basically, consolidation of suits and necessary documents. So the consolidation of two suits is provided for by the civil procedure rules. Check the civil procedure rules, and you confirm whether we are drafting a notice of motion. If the documents are not clear, that means basically we proceed by notice of motion supported by an affidavit. But you have to check the civil procedure rules and understand, because always when you look at each order, then the last rule always gives you the procedure, where either proceeding by chamber summons, and if they are silent, that basically means you invoke order 52 of the civil procedure rules and proceed by the notice of motion. So I have not been in position to look at the civil procedure rules by the time of this debate, of this discussion, but a good lawyer is the one who knows where to find the law. So look at the order that provides for consolidation of suits, and then you can look at the necessary documents. So basically, that was it for workshop 1, and that's what we shall be looking at. But in case you want a detailed discussion with notes on this workshop, you can contact me on the number on my bio. Students in that mentorship program pay a monthly subscription fee to support our research, but we help you to understand this workshop more. We give you quality notes, as well as we proceed to discuss the work on weekends and Saturday and Sunday. So in case you can afford, your budget allows you to be part of that group where we can help you to do research, then you can contact me on that number in my bio, and then we shall add in the group after payment. So workshop 2 aims. The workshop is on procedures and skills of handling objections and conducting an effective hearing of a civil suit. It thus covers a week's learning outcome on the ability of the students to conduct an effective hearing and ESCO issues. So learning outcomes: by the end of the workshop, students will be able to explain how to present a civil suit for hearing in court, to illustrate how to present a civil suit for hearing, demonstrate how objections are raised during the hearing of the civil suit, and prepare ESCO issues. Part A, assume that proceedings under workshop 1 have been closed and all the interlocutory applications herein above determined subsequent rebus counsel were directed by the registrar to prepare and file their respective trial bundles together with the joint scheduling memorandums. Task 1, by role play, conduct a scheduling and subsequently prepare a joint scheduling memorandum. So basically, we shall prepare a joint scheduling memorandum, and I think we have seen how do basically do a joint scheduling memorandum. But what comes out of joint scheduling memorandum is we have agreed facts, disagreed facts, and a list of documents and witnesses. So all those ones arise from what we call a joint scheduling memorandum, where the lawyers are always before the judge, and you have to meet on these specific documents. Then to assume scheduling was completed, draft and file the trial bundles and witness statements of the plaintiffs and the defendants' key witnesses, respectively. So basically, here from scheduling, that's when we have to draft a trial bundle. Basically has all the documents that are going to be relied on by the defense as well as the prosecution. So it has witness statements, plaintiffs and defendants' key witnesses, among others. Then by way of a legal opinion, illustrate how issues are framed, the burden of proof and standard of proof in civil suits. So basically, when we talk about framing of issues, we are looking at Order 15 of the Civil Procedure Rules. Issues can be framed by counsel but also by court. So they can always be on point of law or point of fact. So basically, when one party asserts something and the other party denies it, then the courts can form an issue based on that very subject. Part B, assuming a counsel for the plaintiff advise on the course of action you would take in the following scenarios. Task 2, it has come to your knowledge that the judicial officer handling the suit is the best man of the brother of the defendant. He recently contributed garnishes 500 towards the giveaway ceremony of the defendant's daughter in February 2025. So basically, here you apply for recusal. It's always by way of letter. We have also the case of Owinye Doro, which basically explains recusal of judicial officers. Once you have a conflict of interest in the matter, then you are supposed to recuse yourself. So basically, that's what we call recusal of judicial officers. You had closed your client's case, but forgetting tendering in one of the purchase agreements between Moses Sibua and Henry Chintu. However, the suit before the court today is for hearing of the defendant's case. So basically, you have to seek leave from court to reopen your case. You have to seek leave from court to reopen your case so as you can tender in the document. So if the court grants you leave, you can proceed to tender in that document. Part C, assume that you are the judicial officer hearing the case. The plaintiff had closed their case. The case was fixed for hearing today. Neither the plaintiff nor his counsel are in court. Please proceed. So assume that you are the judicial officer hearing the case. The plaintiff had closed their case. The case was fixed for hearing today. Neither the plaintiff nor his counsel are in court. So basically, because the plaintiff had closed their case, you can proceed to hear the case of the defendant, because now you see the plaintiff had closed their case. You can either adjourn. First and foremost, you can adjourn the matter, but also if the plaintiff's counsel do not show up with no sufficient reason, then you can proceed to hear the defendant's case because they had already finished their case. Then task 3, what steps would you take in the circumstances? 1, both parties are in court and the suit has come for defense hearing for the third time, but the same has failed to take off. The defendants are not willing to proceed, citing flimsy reasons. That counsel for the defendant not prepared well for the matter. So here you can have what we call an ex parte hearing, and you enter what we call ex parte judgment if the defendant's counsel is not willing to proceed. Then 3, the defense counsel has just completed examination of their last witnesses, and the court desires to know from you on how to proceed next before judgment. So basically, we have to go into submissions, written submissions or oral submissions, and then after submissions, that's when the court can go into what we call final judgment after this process. So basically, that was for workshop 2, and that's basically what we shall be looking at as far as this workshop 2 is concerned. Basically, it's not too much work. So let us pass through the workshop 3. The workshop deals with the process of intervention by counsel as an existing suit, contentious and non-contentious applications made to promote interests of justice. The facts in workshop 1 task A will be applied so as to prosecute the main interlocutory application. A learning outcome: by the end of the workshop, students should 1. Explain the process of intervention by counsel in existing suit, prosecution of interlocutory applications, and preparation of rulings in respect of the interlocutory application. So basically, to say that counsel can intervene, 1, by finding not so change of advocates, but also what we called as joint instructions. Then to illustrate the ability to draft appropriate formal applications, replies thereto, and submissions. So we shall be looking at how do you apply for temporary injunctions, and basically how do you reply to those things. Develop ability to demonstrate the prosecution and termination of interlocutory applications. So basically, interlocutory applications include temporary injunction, security for costs, consolidation of suits, test suits, and also attachment before sale. Recognize the ethical issues. We said ethical issues include one, doing proper due diligence under regulations to avoid the conflict of interest, and also making sure that you don't overcharge client. Preparation for references. We looked at cases Chimba Kagwa versus Haji Nasa Katende is a very locus classicus on grounds of application for a temporary injunction, basically on balance of probability, prima facie case, balance of convenience, as well as irreparable damage. Then also have other cases here on the reading list, which shall be good to look at. Also the case of American Synodam versus Ethicon, also on temporary injunctions, McLean University versus Omombeja. Those are all good cases to look at. So basically that was it for the workshop. I believe that you have gotten value from this discussion, and in case you have, please like, subscribe, share, and then comment. But also don't forget to turn on that notification button that you don't you don't miss any videos that we shall be uploading, because we started this journey together and we must finish it. So please, in case you want to join our mentorship program, WhatsApp me on 075 6767284, 075 but that's if your budget allows you to meet a monthly subscription fee of 100,000 per month. But if it does not, this discussion is enough for you, and your notes for the farm are also very good notes. So please don't overstretch your budget. It's for those who can afford. So please have a blessed evening, and I wish you success in your civil litigation.